So can we have global justice through the ICC? First, it is important to make a difference between global justice and international justice. In international justice, justice is made between states, whereas global justice puts an emphasis on individual human beings and justice among them. Global justice considers that every human being have equal worth and that they deserve equal moral consideration. The ICC is an international tribunal and intergovernmental organization located in The Hague in the Netherlands. Its main duty is to prosecute individuals who committed international crimes such as war crimes, genocides, or international crimes. However, it is important to know that it can only interfere in a case when the national courts cannot or do not want to prosecute criminals. Therefore, its main role is to accompany the national judicial systems of countries. Overall, the ICC is composed of 123 states from around the world.
In order to evaluate whether the ICC has been effective in pursuing international justice, we must have an understanding of what the ICC replaced and what its history is. Prosecution of war criminals is actually not a recent phenomenon, but their international prosecution is more of a modern change. The Hague Conventions of 1899 and 1907 provided a codification of the laws of war, and the World Wars accelerated the process of signing treaties and conventions related to war crimes. In the aftermath of World War II, the victorious powers actively pursued and prosecuted German and Japanese individuals for their roles in atrocities during the Second World War via the War Crimes Tribunals in Nuremberg and Tokyo, which gave substance to conventions by actively putting the existing law into practice. Now, the Cold War tensions made efforts of setting up an ICC a bit difficult, so the next big stage in ICC development came with the International Criminal Tribunals on Yugoslavia and Rwanda. These were ad hoc courts that provided the final practical and real incentive for the international community to finalize and codify the elements required to set up a permanent international court. And this came when the Rome negotiations of 1988, which were the final stage of the process of drafting and agreeing to a statute for the ICC, and resulted in 128 articles divided into 13 parts.
The principle of complementarity is essential for the ICC to operate. It promotes the primary responsibility for states to exercise jurisdiction domestically, making the ICC a court of last resort. It balances state sovereignty, and its absence would repel powerful members from ratification to the ICC. States are rational actors whose decisions to join IOs rest on a calculation of the costs and benefits of joining them. The principle makes it more appealing and easier to avoid prosecution. These states have the leverage of choosing which ones to join since they can survive without them. On the other hand, developing countries are more likely to join IOs to prove their commitment towards international cooperation, but are more susceptible to scrutiny of the ICC. The principle of complementarity is a crux in a way, because making complementarity the cornerstone of the ICC ensures that the prosecution of the few does not reflect on the impunity of the many. The ICC's power determines which states are capable of prosecuting crimes at the domestic level and which ones are not, and then seizing that very responsibility for itself is biased and neo-colonial. The distribution of power in the international system makes it hard for the ICC to achieve global justice fairly. It can only investigate matters that are in its jurisdiction or through UN security referral. Again, it is hard to prosecute the most powerful players in the international system because they all hold veto power in the UN Security Council. Powerful players have the diplomatic tools to protect themselves from international prosecution while developing powers do not. The ICC is rarely able to investigate powerful countries and concentrates its efforts on smaller states.
The challenges faced by the ICC when attempting to investigate powerful states is demonstrated in a case study involving Russia, China, and Syria. Syria is not ratified to the court and must rely on a referral from the Security Council to investigate crimes and human rights violations which have been occurring since 2011. Despite demand for accountability of crimes committed, the Security Council has been unable to refer this case to the ICC. Russia and China have both exercised their veto power and have successfully blocked investigations. Another example which demonstrates the challenge to prosecute powerful states is the ICC's attempt to investigate U.S. involvement in Afghanistan. While the U.S. is not ratified to the court, Afghanistan is. The ICC has attempted to investigate crimes committed by the U.S. military and CIA, but has been unsuccessful. Because of this, it has been hard to accurately evaluate the extent of torture and violence committed by U.S. officials in Afghanistan. The U.S. actively refuses to cooperate and recognize the court. Under the Trump administration, the U.S. views the ICC as having no jurisdiction or authority. This undermines ICC legitimacy and limits the court's ability to uphold justice.
As we can see through the case studies of Uganda and the Democratic Republic of the Congo, the ICC can be a bit of a mixed bag when it comes to their involvement in the developing world. In Uganda in 1987, we see CONI and the LRA commit mass atrocities. In the name of peace, the Ugandan government passes an Amnesty Act in 2000 forgiving rebels if they renounce their cause, which many do. However, in 2003, the Ugandan government asks the ICC to investigate in Uganda, and they find ample evidence and issue arrest warrants for top LRA leaders. This creates tension between the Amnesty Act and the ICC arrest warrants. ICC resistance to removing these causes the breakdown of peace talks between Uganda and the LRA. If justice in this sense results in more of war and destruction that brought Uganda to its knees, is it really justice at all? On the other hand, can we ignore the atrocities perpetuated against victims of this order? So now CONI is still large, And if we look at what seems to matter to a great number of Ugandans, it's not justice at all, but peace and food. We could also consider Isaka Suare's writings that argue that the ICC should revoke arrest warrants for greater peace. Does that weaken the power and legitimacy of the ICC? Yes, and it also fails victims of violence, so the outcome seems a little bit unclear. Another case worth examining is in the DRC, where between 1999 and 2003, we see a lot of ethnic conflict between ethnic groups in the East. The scope of the crimes are so big that the DRC referred its case to the ICC in 2004. In 2014, we see success where Jermaine Katanga, who is the leader of a rebel group in the DRC, is caught and found guilty for crimes against humanity and war crimes, but his rape and sexual slavery charges are dropped. Overall, we can see that the ICC does manage to be generally effective because Katanga is eventually prosecuted, but it's problematic that the court is unable to convict Katanga of rape and sexual slavery and also convict two other pretty major rebel leaders, which eventually led to accusations of selective prosecution. It also took a long time to convict Katanga, so while he does go to jail for 12 years and pay some reparations, we don't get a full sense of justice. So all of this points to some promise in the ICC's actions. They managed to uphold impunity, deterrence, and effective judicial cooperation, but their position is weakened by its use of selective justice and time delays.
Firstly, global justice is achieved when international justice is accessible to all, and further, justice must be given to victims and criminal acts must receive suitable punishment. What are the aims of global justice? The aims are to eliminate unfairness in international court proceedings and to not give privilege or disadvantage to certain groups arbitrarily. So the question remains, has the International Criminal Court executed global justice? With the principle of complementarity as a foundational edict of the ICC, jurisdictional limitations occur. As well, notable appeasements for powerful states have weakened the ability of the ICC to fully prosecute global justice violations. While the powerful few nations are able to use veto powers to avoid investigations or prosecution, developing countries are held to a different standard. Examples of atrocities that have been presented demonstrate the failure of the ICC to fully fulfill its mandate. As a result, only an appearance of universality in the application of justice has been evidenced, with some states wielding the power of indemnity. It is this fragile facade that limits the ICC in its capacity to execute global justice worldwide.